Okay, well, if we could call the meeting to order and ask the clerk to call the roll, please. Here.
Here. Counsel Nguyen.
Here.
3 present.
Okay, this is, I believe, the third in a series of meetings held by the Public Safety Subcommittee at the suggestion of the Citywide Neighborhood Group to address various matters in the city as they relate to public safety. The topic of the meeting this evening is a discussion concerning health codes related to single and multifamily dwellings. I think there'll be time for, and I would like to acknowledge the presence of, I guess, 4 other city councilors, Councilor Laurie, Councilor Mendonça, Councilor Mercier, Councilor Leahy. So why don't we get started? I guess, for me, I would like to, and I know we have Mr. Slagle here, Mr. Marcilla from Inspectional Services, as well as the manager. I think it might be a good idea to get a distinction about health versus building codes, how we go about the inspection program. I know we've still got the housing inspections that are being rolled out. Mr. Manager, if you have any introductory remarks, or first I should ask members of the subcommittee, anything? Okay.
Thank you, Mr. Chairman, and I actually don't have any introductory remarks. I'll turn it right over to perhaps to Mr. Slagle to address some of those initial questions that you put forward. I do think that I say I don't have any introductory remarks, and now I'll make some. But you know, I think that the new ordinance that we're enforcing now is really giving us an opportunity to put enforcement of the health code at a much more visible level, a higher priority than it probably has been in the past. So I think that our health inspectors have become even more significant over the course of the last several months than they were before. But I'll let Mr. Slagle walk through the differences and give a sense of some of the problems or issues that we're addressing with our code enforcement people in the area of health.
Thank you, Mr. Chairman. Currently in development services, we have a staff of 5 health inspectors, 1 senior inspector, and 4 local building inspectors and the building commissioner. The health inspectors are tasked with the enforcement of the sanitary code, and conversely, the building inspectors are tasked with the enforcement of the state building code. While those codes do in some places overlap, the primary goal of the building inspectors is to evaluate the appropriateness of the construction of a building and the kind of the structural elements, whereas the sanitary code inspectors are involved with issues more related to health and safety. As an example, our sanitary code inspectors enforce solid waste violations, minimum maintenance violations for both the exterior and interior of the building. They evaluate issues inside of units, such as the presence of smoke detectors, the operation of an operational stove, an operational heating unit. They are trained to be able to identify lead paint inside the units, though they are not lead paint inspectors, and we have a referral process to refer those lead paint that's been identified to the state. They also work on issues such as screens and windows, whether there are hollow doors leading into and out of specific units. I think, do you have anything else, Robert, you wanted to add to that before?
And a big part of what they do is respond to complaints for vermin and pests, nuisance, that type of thing. That comes under the purview of the health as opposed to the building.
Right. So issues with bed bugs or any kind of as Mr. Marcelli said, any kind of pests in the unit. They also are tasked with doing our food service inspections. So any restaurants or food service establishments in the city, any complaints we get about those go to our health inspectors. They also have the enforcement authority over the dumpster ordinance. And so any of the commercial dumpsters that are on the exterior of buildings, our health inspectors have that as part of their purview. Again, the building inspectors, the plumbing inspector and the electrical inspectors, who are also in our office, they have fairly well-defined roles. It's plumbing and electrical work. The building inspectors deal with the framing and the structural integrity of both the main structure and any kind of ancillary structures, decks and garages, anything that involves the requirement for a building permit that falls under the building code would fall under the purview of the building inspectors. Again, things like smoke detectors and CO2 detectors, I think there are issues in both the codes that have to do with those. So, but all the inspectors in the department have actually had a kind of a basic level of cross-training, so that then they can identify issues that they would need to refer to kind of their counterpart inspectors. So our health inspectors have been trained, and we have a policy so that they will, if they see anything in a unit that they're inspecting that would trigger a potential building code issue, they refer it to our building inspectors, and vice versa. The building inspectors will refer any kind of health or sanitary code issues to one of our health inspectors to investigate. Having the department merge the way it has been for the last couple of years has actually worked really well in the inspectors getting to know each other personally and getting a familiarity with the scope that their opposites work under. So I think that's been a fairly successful consolidation. I think that's kind of a basic highlight of the differences between those two roles.
What about levels of training or certifications, that sort of thing? I think they're probably pretty specific on the building side. I'm not so sure on the health side.
Local health inspectors are required to be ServSafe certified, and all of our health inspectors are. We have additionally instituted some kind of additional training in various topics for our health inspectors. There are some online courses and a 3-day seminar put on, I think by the state, every year. And we will be sending our health inspectors to this 3-day seminar. The online training involves lots of different fairly specific issues. There's a specific training on bed bugs, there's specific training on residential pools, there's a specific training on food service. And so we are kind of going above and beyond the required certifications for the health inspectors to try to give them extra training so that they'll be able to respond to appropriately in the situations they find themselves in. The building inspectors are required to be certified within 6 months of their hire date by the state. That involves passing a series of tests, and the tests for the building inspector certification are fairly rigorous, and it's a kind of a statutory requirement that they have those tests in order to be certified with the state. In addition, I know that our building commissioner has an additional level of certification that he was required to obtain from the state to be a building commissioner that goes kind of above and beyond the basic local building inspector certification.
Okay. Other questions from subcommittee? Councilor Elliott?
Thank you. On this certification, Mr. Slagle, the certification for health inspectors is state that they have to go through a similar process that building inspectors have to go through?
It's
They have
called
to
a
take an
s-
exam?
It's called a Serve-Safe certification. It's not the same type of certification as the local building inspectors are required to have. I believe it's actually open to private individuals as well.
It is, I'm ServSafe certified. It's the only requirement the state has for the local health inspectors.
Commissioner, could you use the microphone? Only this is televised.
Yes, the health inspector is required to be ServSafe certified, which is completely related to food service. The other sections of the code, which is 105 CMR 401, it's related to nuisances and other types of things. There's no specific training that they have to receive for the state in order to act as a local health inspector. So we provide that training in addition to that, as Director Slagle's already mentioned.
So our inspectors are certified to do food service inspections
Correct.
as well as be able to inspect the other aspects of it.
The other components of 105, there's not specific certification required. They're trained
So
on the
does the state just test for food service inspection? Is it an exam or
Third
is
party.
it just?
It's a third party that does the testing that the state
Okay,
requires.
same thing with the state building, with the building code inspectors? Is that third party or is that literally run through the state?
Yeah, no, the state has adopted as part of its code, the international codes, as you know, ICC. And so the testing and the certification process is a joint process. It's basically, we're tested on the international codes through an independent testing authority. It's Pearson View, and the test results are forwarded to the state,
Okay.
approved
So-
by the DPS.
At the last meeting, or I think it maybe was the motion that I had filed about the inspectional fee, or maybe it was just a general discussion about the number of units as a result of this new ordinance. Have we been able to determine, because I know at that time, Mr. Bakey had just indicated that it wasn't known how many units there wasn't a definite number of units that were known, that we just took it off the census data. Have we been able to trying to find out exactly how many units will be inspected under this ordinance?
Yeah, as I think I mentioned at the last public safety meeting, unfortunately, that the number is unknowable as of yet. We probably won't know the total number until after 2015, in part because our proactive efforts to obtain applications, as I mentioned before, we divided the city up into thirds, and so in the goal of having approximately 1/3 of these permits renewable each year, so that we're not overwhelming the health inspectors in one year and then not having the same number as having no inspections the next year.
So how are we sending out notices to those individuals? If we don't know how many units, how do we know who to send notices to?
Okay,
And I guess just to follow up, because I think you can wrap it up in your answer. Are we going to be able to, how are we going to find out those units illegal units? I mean, we all know that there are illegal units, we all get complaints. Neighborhood leaders certainly get the bulk of the complaints, so how do we go about identifying that? Even if it's a single family or a two-family that's converted to a three-family.
right, and that's a challenging question, and it has a couple of different parts. The first question is, I didn't mean to give the impression that we don't know how many units there are in the city. We simply don't know how many units are going to require inspections, because the exemptions that are put in in the ordinance for two-family owner-occupied and for units that have the HUD inspections, because those units don't require an inspection, and we simply don't know exactly how many of those units exist in the city until we receive applications from every rental landlord in the city. We won't know how many of those units fall under the exceptions. Additionally, we also don't have a clear picture of the number of owner-occupied units in multifamilies there are in the city, and that, because those owner-occupied units wouldn't be defined as rental units under the definition in the ordinance, they wouldn't require inspections. So if you owned a three-family and you lived on the first floor, that first floor is not a rental unit as defined in the ordinance, and so wouldn't be inspected. But until we get in applications, we simply don't know whether or not the three-family you own, whether you live there or whether you live in Drake. We simply don't have that information.
How are we going to find that out? I mean, if somebody doesn't return an application, we won't find out, right?
Well, I think now what you're moving into is kind
I'm
of.
sorry, the home, the homeowner that's living there that has, a 2 or 3 unit.
Right. I think what we'd be moving into there is kind of the next phase of enforcement, which is attempting to capture the rental units where we're not receiving applications. We have taken made some preliminary plans for how we're going to attempt to capture those units. We will. Right now, we have a bit of a backlog of applications that have to be data entered and inspected. So at the current time, we have plenty of work for our inspectors to do and for our clerical staff to do to input the applications that we have on hand. That being said, by the end of this month, the plan is for us to pull out a list of, from the applications that we received, a list of the units that have applied, the addresses that have applied for a permit under the ordinance. And from the assessors, we have a list of the multifamily properties as assessed by the assessor's office in the city. So we'll kind of, I apologize, we'll kind of merge those lists together to eliminate from the general database of multifamilies in the city, everyone who's applied, and that should leave us with the people who have multifamilies who haven't applied, and then we'll do some kind of further outreach efforts to those individuals. Inevitably, there will be some landlords who just don't apply. Under the ordinance, they're subject to a potential fine and, more importantly, to the removal of their certificate of occupancy. And if we reach the point where we make the determination that that's an appropriate step to take, it would be the building commissioner's determination under his discretion to take that step. But if we do, that means they can't have any tenants in the building. They won't be generating any income. Our hope is that's kind of the last step option, other than taking them to court, to try and mandate that they obtain this rental permit.
So on these housing, on the HUD, whether Section 8 or LHA, those units, how does the process that triggers, firstly, how does the process where you're going to do a sanitary code inspection, and if the inspector does find potential violations or other violations of building code, then with city, with the city process, the building commissioner is notified, or the building department, and then they go in and they do the inspection, correct? How does that process work with HUD units when they have their own inspectors and they're not certified building inspectors? They're certified through a third party, I presume, just in, probably not even food service, right? Just the general, health issues, bed bugs, roaches, things like that, they go in. So knowing we've had some inspectional issues with LHA, how do we know that there are not building code violations that need to be addressed? Because let's face it, the tenants are going to be afraid to say something.
Right. I mean, that is a challenging issue. We are not in any different situation than if this ordinance didn't exist, which is that if you're talking about internal building code issues, the only way we would ever have any knowledge of them is if somebody who's in the building informed the city. So we've taken the step of training our inspectors so that when they get into these units, that they should refer it for building code enforcement if there's an apparent code issue. The way that the ordinance is drafted and the way that the council passed the ordinance to grant that exemption to the units that obtain HUD certification, I believe that the goal in that was, number one, to not duplicate efforts, because the HUD certification is a bit more in depth than the certification that our health inspectors do. There's a bit deeper depth. And so it's simply an allocation of resources. We have a number of inspectors that we can use.
But if I think I can answer what the councilor is alluding to. In those units where there's Section 8, in most cases, in many cases, it's not the entire building. It may be 2 units out of a 6-unit building. So our inspectors are in the 4 units that are not HUD certified. So it would be unusual that 2 units were completely atypical compared to the other units. So we're in the building, we're in the common areas. If the building is in bad shape, we'll know it. But we can't get in every unit in the city. So, I mean, and the other part of this that should give you some comfort is the checklist and the process that the HUD inspectors go through, I'm familiar with. It's very thorough, and they do a good job. So I think there's very little chance that we're going to let a lot of things slip through the cracks in terms of the ones that are inspected by HUD and not our people.
Well, my understanding is that HUD inspectors are not as thorough as city inspectors. They're certainly not certified to be food inspectors, which is the next level up. But I also understand that the federal code is not as stringent as in Massachusetts. And depending upon what state, if you look at the state health codes or even the municipal health codes, if the state regulations are strict, and they would supersede the HUD inspection. So it would be, if possible, I would like to see a copy of what those codes, those regulations are, and the thresholds that they have to pass. And maybe I'm wrong. I mean, I hope I'm wrong, because it's not about who's right or who's wrong. It's about who, the level of scrutiny or, inspections that have to go through. But just to follow up on my question, what is the process if those HUD inspectors do find something? I mean, presumably they should be calling the city, but does that happen? Has it happened where, whether it's a separate standing multifamily unit, which makes some sense, by the way, or, if it's a housing complex? I mean, who's to say that some of these units are not in compliance, which clearly, knowing the renovations that have taken place, they're not up to code, and that's one of the reasons why they're being updated or upgraded. So how do we know that? I mean, how does the city know, okay, maybe the HUD inspectors passed it for cleanliness, but there could be multiple building zone violations, building code violations? You follow me?
No, I follow you, and I think we're kind of in the same situation that we would be without this ordinance, which is,
Right.
which is that while this is a tool in our toolbox to try and obtain compliance from the landlords in the city, oftentimes the only time that we will be made aware of potential building code violations is either through the proactive enforcement that our building code inspectors and our health code inspectors do, where they're observing their surroundings as they're driving through the city, or when we get notified of a problem from somebody who's been into the building, whether that be a HUD inspector or a tenant or a landlord or a neighbor who notifies us that there's a potential problem. So those are kind of the ways that we obtain that information now for all the units, whether they're rental units or owner-occupied units in the city. And we have to rely on the tools that we have in order to...
I think this is a good ordinance. I voted for the ordinance. I did express my concern at that time that the city was not going to be performing the oversight. I also understand there's no need for duplication of effort, but when it comes to building code issues, they're really, in this case, the ordinance is good because it forces landlords, or it encourages landlords to keep their properties in good shape. The city is going in on a 3-year, on a triennial basis, and so knowing that, I mean, it's kind of self-enforcing. They're going to make sure, landlords are going to make sure that their properties are in good shape, not just from a sanitary perspective, but also from a building code violation. And we know that's one of the reasons why we put it in place. It happens time and time again. And so my point is, it happens with privately owned units. It certainly happens with publicly owned units. So how can we provide the oversight on those units to make sure that they are in compliance? Is there a system where the HUD inspectors, and maybe this might be an amendment to the ordinance, if publicly owned units, if they do find violations, there's a requirement to call the building inspectors in the city, because right now, I suppose under state statute, they have to, but is it happening?
Well, I can tell you what I've done so far to that point, Counselor, is I've had a series of meetings with the two main entities that supervise the Section 8 housing in the city, and that being LHA and CTI, in preparation for the ordinance, and since the ordinance has been enacted, we've had several meetings, and one of the topics of discussions had to do with, in instances where there are some issues that are observed, they don't issue the certificate so they can't occupy the unit. We don't get notification of that. The landlord is notified that the unit hasn't passed. He's given a list of items to repair before he can rent the unit. The inspector has to come back. So that we don't have access to. But we do have open communication, and I have asked both of those entities, LHA as well as CTI, to instruct their inspectors that report to them to notify my office if there's any building component issues that they notice outside of the apartments that they're inspecting. So I think that'll capture some of the items that you're talking about.
Okay. I understand, and I think that's, a good step, but on the other hand, there's no incentive for them to report this because it's going to require more work, it's going to require more of a cost. So, moving forward, maybe we can, think about, I'll think about how we can put a mechanism in place to make sure that, if HUD inspectors do find something, that they do report it to the city and there's a requirement. Right now, there's no requirement other than if it's a state building code violation, right? Okay. Thank you. I appreciate it. I do have one more question, but I've had the floor long enough, and it's just regarding the fee.
Councilor Noon?
Thank you, Mr. Chairman. The total number of health inspectors we have now is 6. Is that correct?
Yes, it's the five health inspectors and one senior health
Are
inspector.
they all certified by?
They are, yes.
Is it renewed annually, or how often do they have to recertify?
I believe they have to go back every 5 years.
I see. I believe that you have cross-training, and cross-training happened when you consolidated the inspectional service. Is that correct?
Yes, there's cross-training that happened when it was consolidated and ongoing with we've
Is that
had
an
new
in-house
inspectors.
training?
It is.
And do they also receive online and, on outside of the city training to help them get an up-to-date tool or know-how to enforce certain health code and stuff?
Yes, we have as I said, the online training that we've instituted for the health inspectors, as well as the annual conference for the health inspectors. It's a training conference. Our building inspectors also go through kind of rigorous continuing education as required, I think, under their certification. So they're continually getting continual training about the building code as well.
We are 1 month into enforcing the new ordinance. What have you learned, or what are some of the common problems that the inspector or building and health inspector encounter?
Well, I think they run the gamut. We've had health inspectors who have inspected units that were completely lacking in heat and hot water, didn't have a working stove, and the only heating was through an electric plug-in heater. That health inspector immediately shut down the building and ordered the landlord, the owner, this was a bank-owned property, to remedy the violations. The bank did. The tenants are back in the unit, which is now fully compliant. But the kind of run-of-the-mill issues that the health inspectors run into are non-working smoke detectors and CO2 detectors, lacking screens, uncovered electrical plugs. We've trained our inspectors to proactively give the landlords an idea of the items that they're going to be looking for before they do their inspections, for 2 reasons. First, to try to minimize our re-inspection efforts to try to make our inspectors' time as efficient as possible. But second, to give the landlords an idea of these are the kind of things that we're looking for, so our inspectors let them know the kind of laundry list of issues that they're checking for. And we've had several landlords who said, oh, I was going to have it for tomorrow, but do you mind coming in next week? And obviously, they wanted to get some of those issues corrected, and the inspectors have gone out and the units have passed because we're having an effect on the quality of the units even before we actually get in and inspect, because the landlords are proactively bringing up the standards of the units when they know that the inspection is imminent.
So you do send out some of the, send out the laundry list, so to speak, you said, prior to going in to inspect the property, is that?
Right, well, it usually takes place in the conversation that our inspectors have with the landlords when they're scheduling their inspections.
And if they don't know what some of those lists, they can always call the inspection service to get those information as to, you know what, you're coming in next week, what are you looking for? Something like that, can they call in and?
Absolutely, they often do, and as I said, our inspectors are proactively telling them when they're setting up these inspections, these are the things that we're looking for.
Yeah, and I think we talked about this last week too, Councilor Leahy actually, and I were talking about this a few weeks back. The idea being that with the new, as we continue to roll this out, we will be sending out a listing of the types of things that they'll be looking for.
Actually, one more question, Mr. Chairman. The commissioner spoke of the level or the communication that he had with the the Low Housing Authority as well as CTI. Would you continue that dialogue so that you have some sort of not just communication but collaboration between the agencies, so that in going forward maybe address some of the issues concern that was raised by Councilor Elliott?
Yeah, certainly with LHA, I have regular meetings with them because they have other projects going in the city, and this will be the subject of discussion as well, ongoing, HUD-related inspections. CTI, I will certainly do that, have regular meetings with them about this.
Thank you. Thank you, Mr. Chairman.
Councilor Laurie?
Thank you. Just to follow up on Councilor Elliott's question, if someone has Section 8 and the inspectors come in, they don't have to notify us if they find violations? Is that what I heard?
The Section 8 inspection happens when the unit is vacant,
Right.
when they're preparing for a new tenant to occupy the unit. There is no regulation under the HUD regulations that requires if a unit doesn't meet the standards in the HUD regulations, there's no official requirement that they notify the city that the unit would be in violation of HUD regulations.
Do they notify the city in any way that they've done an inspection?
We don't get notification that they do those HUD inspections, no.
As part of the program we signed off on a couple of weeks ago, if you get Section 8 or CTI, the LHA has apartments, they have their own inspection teams,
That's correct.
and we don't have to inspect them.
That's correct.
So, from that point, someone moves, they go and inspect that apartment, we get a form saying they inspected it.
Well, it unfortunately doesn't work. The way it actually works is because the rental unit permit runs for 3 years, when the application period comes up, there's the exemption in the ordinance for units that have had a HUD inspection. So if they've had a HUD inspection and they provide proof to the development services that HUD inspection has occurred and they passed the HUD inspection, that HUD inspection is recorded in our system, and
Okay.
that they will come up for a renewal cycle in 3 years where they will either have to obtain a permit and get an inspection or provide us with evidence that they have a HUD inspection.
Now, in the meantime, someone moves, they have to inspect the apartment again.
Correct.
They find a violation. Isn't that fraud? We have ordinances in this city that we try to protect the neighborhoods, we try to protect the people in the buildings. Now, I own a 6-family building. I have 2 people that, say, Section 8, and 4 who aren't. Their inspectors go in and find violations. They don't report them to the city. they put the other 4 families in danger. Isn't that fraud?
Well, I don't think it's a wise practice. I'm not quite sure it's fraud, but I think the challenge that we're
If
all.
they sign off on that form, or they gave the city any type of idea that that apartment was safe and it's not. I'm not an attorney. I'm using the word fraud. But isn't that misleading the public, that those buildings are safe when they're not?
Can I just say, look, the issue that we should be focused on are not the units that get inspected all the time. I mean, anyone who's ever been through a Section 8 inspection or had a client who's been through a Section 8 inspection, as I have many times, they are much more rigorous than the inspections that the city has gone through whenever the unit turned vacant, which was 10 years, 15 years, maybe every year, but you never know. So now what we've done is put in a system of regular inspections so that you don't have to go 10 years. You're going to get a regular inspection. And these other units that are already being inspected are going to continue on as they have been for many years. We're going to add now to try and make these other ones up to code compliant. So I think if the council is missing the point, if we're thinking all these HUD and CTI inspections are slipping through, they're doing a much better job than we've done. We're trying to catch up to them, not make them catch up to us.
I'm not suggesting they're slipping through. They're doing the 3-year requirement as we're doing. What I'm suggesting is, what I'm asking, is if they go into the apartments in between the 3 years and they find something that's really a problem, I would think they would at least notify the city. Whether they're required to or not, I think the practice for their own tenants, they would want to notify the city.
Well, I think, if I may, Mr. Chairman, I think the issue is, though, when they go in and do the inspection, they will not issue a certificate, they will not allow the unit to be rented under the Section 8 program if it doesn't pass the inspection. That's the whole point for them. For HUD's concern was that we're giving out these certificates, and we don't want these units to be, in poor condition. So they do go through this, and I am familiar with the Section 8 process, that they do put them through on a regular basis, these inspections. But that's the downfall. They might refer, if they see something, I would assume that, if it's something that's more of a building safety issue, as opposed to a health code issue, they would contact the local building authority. They would not give a certificate, and I would imagine they might contact the building department of a community. I do think that there's issues with the city or any local government requiring the federal government to do anything. It doesn't happen.
Oh, I understand that. You can't tell the federal government what to do.
Right.
But I think, to be fair with our own inspectional service department, if they find something, they would at least let you know. Because we're trying to keep a certain standard of apartments or a living condition in the apartments. So the only point I bring up is if they do find something, I would hope they would notify our inspectional services so we could follow up and make sure the other apartments are safe. I'm not knocking our inspectional services. It's the lack of communications that they would receive from another agency. That's what concerned me.
Right, I think it's important to point out that historically, in the experience of development services, we don't have issues generally with the HUD inspected apartments. The Section 8 apartments are generally in better shape than the average apartments in the city because of the kind of rigorous inspections they have to go through on a regular basis. The ones that we have, that I think that we are trying to target in this ordinance, the ones that we think are a priority, are the ones that have never been inspected by anybody.
Oh, absolutely.
Those are the ones that I think the neighborhood groups legitimately have issues with, the ones that never called for their vacancy inspection. when
I
they
have no
exist.
problem, I agree. It was just I picked up on that comment when Councilor Elliott was asking questions that they're not obligated. I worked for the government for 33 years, and I know how they can be when they're not obligated. But it puts our own people in a position sometimes. Very quickly, the other question I had was on apartments that aren't registered. I was a mailman for 33 years. It's something we would see. One indication would be when your inspectors go is the number of mailboxes with names on it. I would go, the last one I had an apartment with, building with 3 names. I don't know how many apartments are legitimately, I would just leave the mail off. Well, that owner gets cited for having an illegal apartment, but the inspector would know that there's only 2 apartments. So when they visit the house, take a quick look at the mailboxes. If there's names on it or mail in there, there's probably a good indication is the apartment. And because parking is usually the first thing that goes crazy. The other question is if someone owns multiple apartment buildings and you do find that they did have a location with an apartment that wasn't registered, do you check the other buildings very quickly?
There are a couple of issues, and I wanted to take a step back. Our inspectors are proactively trained in how to respond to allegations of multiple or illegal
Right.
units. Mailboxes is one sign, number of meters is another sign,
Right,
number of
right.
satellite dishes, exterior vents, those sort of things can be triggers when our inspectors go to a property that there's a potential legal use there. A single family that has 3 meters, for instance, is a challenge. In a city as old as Lowell, the other challenge is there's a lot of grandfathered units in there that may not meet the current
Right.
zoning requirements. So while this may be zoned for single family or 2 family, that doesn't mean there aren't perfectly legal 3 families in the zone, because they were pre-existing 3 families.
The question is, though, if you find someone that does have an illegal legal apartments, and he has other apartment buildings around the city, do we check those very quickly to see if he's doing it anywhere, or they're doing it anywhere else?
Not exclusively when we find that they have illegal apartments, but just when we find a building, for example, that's run down and we know, because we have a lot of people that live in the city and they have a lot of institutional knowledge, that they own several properties. And that'll be the catalyst for us to check
Sure.
the other addresses and find typically that there's similar problems. So we do. Yeah.
That was, yeah, okay, thank you.
Councilor Mercier.
Thank you, Mr. Chairman. I'm glad that this department, Developmental Services, merged with the Health Department and the Building Department, because I believe that people call up and they really don't know if it's a health issue or if it's a building issue, and yet you're calling one number and someone in that department can put you to the right person without saying, oh, you called the wrong department, you gotta call the health inspector. So I think that's wonderful. Now, there's 6 health inspectors. How many building inspectors are there?
We currently have 4 building inspectors plus the building commissioner has a certification as a building inspector as well.
Now, I know that they go out and inspect things, both the health inspectors and the building inspectors. Is there always someone in there that can answer the phone to tell you, to calm you down and tell you what's going on and this, that, or the other?
One of our inspectors is currently assigned as a plans reviewer.
Okay,
So the bulk of his time is spent in the office reviewing the building plans that come in that require a plan review before the permits are issued. So he is generally around. We also have a very knowledgeable clerical staff. Our office manager has been in the department for a couple of decades. And though she's not a certified building inspector, she certainly has the institutional knowledge to understand where to refer someone for an answer and how to get the answer if we don't have. In addition, all of our inspectors have been issued city cell phones, so we have access to everyone, including up to the building commissioner. if there's an issue that kind of needs urgent attention from a particular inspector or needs an input from the building commissioner, we have access to them at all times.
That's good. And I know years ago, the inspectors were assigned different territories. Do we still do that now?
Yes, the city's broken up into thirds, so we have one of our building inspectors is doing plans review, 3 of our building inspectors, one is assigned to each
Territory.
third of the city, yes.
So
that's
if I call up and I say, there's a problem in Pawtucketville at such and such an address, they assign a certain person that is assigned that particular area, right?
Yes, his name's Martin Furtado. He's the inspector who's currently assigned for Pawtucketville.
Okay, that's fine. Now, did we ever get anything on the website to tell people what you need to pull a permit for and what you don't? Did we ever put that on the website? I think people should go into their computer to the website and see a list of things that you need to pull a permit for. For example, I ran into someone last week that says, I want someone that's gonna paint my house. I believe I need to pull a permit. Now, I'm ignorant about this, I'm not a professional, and I said, the last I knew, you didn't need to pull a permit to paint your house. Is this right, that I give them right information or not?
You are correct. You do not need to pull a permit. Would you like a job?
Well, but the fact remains that these people didn't know, and if the public knew that they could go online under the city's website and know what you need to pull a permit for and what you really don't, because we want to beautify our city, and if people are under the impression that they got to pay for a permit and pull a permit to paint the house, just how beautiful this would be if they realized, gee, I don't have to pull a permit, I can paint my house. Now, let me ask you this. If you wanted to vinyl side your home, if you hire a contractor, I believe he needs to pull a permit. But I think that if you do it yourself, maybe you don't. So I don't know. What's up with that?
If it's your own building, 1 or 2 family, you live there.
Yes.
You can do most of the things that would require a license elsewhere on your own.
On your own.
One of the problems with that, and there's a whole list of things that are, that go along with that. And we have a list that we give out when people choose the homeowner's exemption, is what it's called under state law.
Right.
Basically, it's not there, and not everybody understands this, to allow you to hire a contractor who then doesn't pull the permit. It's specifically for a homeowner doing work in his own home, 1 or 2 family, himself, or with his son, or a family member that may have some skills. It's not intended to allow a homeowner to go out and hire somebody who then doesn't have a license possibly and is gonna
Right.
do the work without a permit. So we run into that all the time, and it's something that we warn homeowners up front that they are not supposed to do.
So I'm asking if you could please put the basic things on the website, what you need to pull a permit for, and what you probably don't.
We have several facts, frequently asked questions on the website now.
Oh, you do?
We update it regularly.
Okay, that's fine.
And-
That's helpful for the public. And I just have one last question. Let's say that I receive a call from a constituent that says there's some sort of a violation problem going on at this particular property. And I tell the proper department, and they go there, and they can't get in. What happens then? Do we just forget about it, or? Because sometimes people will not let you in. What is the procedure there?
Right. There's a couple of different levels. I mean, our building inspectors have the right of entry to any common area in any property. That includes any apartment building. They have the right to enter and access any common area. We do rely a lot on external factors in making determinations to whether or not there's a probable cause for us to enter into a building or claim that there's a violation. In addition, I know we've taken this step in the past. Our inspectors can go before the housing court to get a probable cause warrant if there's an imminent health or safety issue, and they can get a warrant to have access into the property through that means as well.
So you probably, Eric, are using your legal skills in this department as well. So that's a good thing, too.
I'm not a lawyer, but I play one on TV.
Oh, good. Thank you.
I know there are people from the public been waiting patiently. Does anybody have questions or comments?
Get to go first again. Taya Dixon Mullane, Lower Highlands Neighborhood Group. First off, I want to say that this ordinance that was put in place is a huge and vast improvement over what we didn't have before, which was basically nothing. But just so that we're clear on why we're at the Public Safety Subcommittee, there's a direct association between poor management and maintenance of buildings and crime. I know this because I live across the street from one. I know there's been some discussion about the fee, the $50 fee. I don't think it's $50 every 3 years is too much for the cost of doing business to rent a property that's about $1.34 a month for 36 months. If you can rent a property in the city, I think you can afford that. It pays for the staff. This should be a self-sustaining program. Not everybody rents property in the city, and those who do should pay for the inspections because it affects everybody. One thing that you didn't really talk about tonight, but when the ordinance was first being discussed, one thing that I brought up, and I know other neighborhood groups brought up as well, is something I want you all to think about, is including all rental properties in this ordinance. That's single-family rental properties and units that are rented in owner-occupied residential units. Because this will ensure that all residents are going to have healthy, safe conditions to live, and the neighborhood gets to enjoy the fact that they have a healthy and safe neighbor. Because one thing that I know from experience, I'm in low-income housing all the time, rehabbing buildings, that you cannot expect all residents to speak up for themselves because they fear losing a roof over their head. So the city has to be involved in this, and this problem doesn't just exist in multifamily buildings, it exists in single-family and owner-occupied buildings. So thank you very much.
Anne Marie Page, 26 Fremont Street, Lowell, Citywide Neighborhood Council. We know the time is real tight here, so we'll make it quick. We just want to see teamwork. We're glad to see the departments have consolidated. We're glad to see they're tightening the belt. We know we're going in the right direction. We just want to shift it into the next gear. But we want to see teamwork, right? There is no reason why. We know HUD does very intense inspections. There is no reason in the world why they can't send a copy of that inspection into our inspectional services so that we have it on file, right? And that's not an invasion of privacy. If the taxpayers are paying for that HUD project, then the taxpayers should be protected by our inspectional commissioners having a copy that this property was inspected and it is safe. Because as Councilor Laurie had said, what if that's a 4-family and they inspect number 1 and number 1 fails? Then we're concerned of the safety of the other 3 families. So I think same thing, whether it's HUD, Lowell Housing Authority, or CTI, if they're inspected by their own private inspectors, a copy of that should be sent into the City of Lowell inspectors, even if it's just to be reviewed quickly and to put on file. We want to work as teams. And we also realize there are certain things inspectional services can and can't do legally. So we want you to let us know what your limitations are so we can sit down and talk with Mr. Nangle, Mr. Murphy, Mr. Golden, and Mrs. Saunders. And if we need help, we want to get it. We thank you for all your hard work. Keep up the good work and shift into second gear. Thank you.
Do I get 1 minute?
Yes.
Sure.
Okay,
Yep.
Deb Forgione, Pawtuckettville Citizen Council. And I guess I'm going to stand here and ask for advice. I think I sent to all the councilors a sheet on a property that had 34 violations. 34 violations from all the different, if it's building, and it was health, and it was zoning. That's the task. I don't know if we can do this next month and talk about how this is all going to work, but if one property had 34 violations, there needs to be a coordination. There was a temporary structure, a permit given for a temporary structure. While that temporary structure was there, there were 17 violations with conservation. So that's the task at hand. We're asking for your help to make sure. So if that was blatantly and documented, And we showed that there were 34 violations on one property, and that was something that was seen by people that live in the area. I suspect that this probably happens in other areas, not as aggressive or as, not as bad, but it's just, did seem to be that there wasn't something that would trigger another department. So, thank you.
Okay, thank you. Councilor Elliott?
Yeah, I know we're against the clock, so I will be brief. Commissioner, Westminster Village, weren't there multiple building violations at that development? And I think they were issued a cease and desist order, or there were major complications at that project?
There were over 200 permits issued. There were several instances where we found issues and notified the property management company, and they resolved them. In one case, we had workers working there without workman's comp, so we called the state. They responded the same day. We all met out there. Those workers were dismissed, and one of the problems with Westminster Village is it was purchased by an out-of-state company. I believe they're situated in New York.
Okay.
So they tended to hire contractors from New York that didn't know, weren't familiar with our laws, and so that was part of the problem. But after several meetings, which I had with the owners and the developers and the contractors and our building inspectors, the last phase of the project, and it's about 95%, 98% permitted now, COOs issued, has gone smoothly.
How many Section 8 vouchers are issued are issued to that particular property?
I don't know. I believe it's almost entirely either Section 8 or HUD.
Had your department ever received any complaints of sanitary or health code violations from that project?
I believe we have, yes.
You have from those HUD inspectors that went and made inspections over there?
No, we received
Okay.
complaints from
This
tenants.
exactly is my point earlier in my line of questioning, where some may think that these inspections are more rigorous than the city, but here we have Section 8 vouchers, hundreds of units, and as far as I'm concerned, I don't know what the standard is, but it should be consistent, whether it's HUD or private. And whatever the most stringent code is what we should be applying, both to these Section 8. My concern is, and Westminster is a perfect example, if there's not that check, if there's not that balance with the city, it's going to continue to go. I mean, maybe it's, I don't know if it's just going to be, the housing authority or Westminster Village, but if there's no check, I agree with Councilor Laurie. If there's no obligation, if there's no way to close that loop, there's going to be violations. And we all know whether it's public or private rental units in the city, there's plenty of examples of substandard housing, which is why we put this in place, which is why the neighborhood leaders cry for it. So I don't know what the standard is, or one's more rigorous than not, but there's an example where that fell through the cracks. So
Well,
that's really my
just
concern.
One clarification there. The complaints that I'm aware of that we got from Westminster had to do with things other than, because we've been in every apartment. They've all been redone. We had trash complaints, trash was building up outside, that type of thing. The apartments themselves, once they're renovated, we haven't had any complaints. We had one complaint for a suspicion of asbestos, but it had been dealt with, and so there haven't been any big issues that I'm aware of that would be the result of like falling through the cracks.
Okay,
Because we've been there.
We have to bring this to a close, so let me just say this, that this matter of the ordinance is pending still before the Housing Subcommittee, and I think one of the things that I would like to take up is you need to provide some information about your other government inspection to get the exemption. Maybe we amend it to require a copy of the report too, but we take that up at a meeting of the Housing Subcommittee when it meets on the ordinance. Okay.
No, the only, Mr. Chairman, the only thing I was just going to clarify, I think that the complaints we were receiving with regards to Westminster, I believe, were more related to the building project going on than the occupancy issues that this ordinance is designed to deal with. But we can clarify that, and we'll get back to the subcommittee on that.
Just a response. I think, I don't know if it was, I forget which neighborhood leader it was, but I think it was Ms. Dixon, she's right, especially with public housing units, whether it's Section 8 or otherwise. Tenants are not going to come forward and say there are building code violations or sanitary code violations. So that's really just my concern. What is the mechanism if a HUD inspector goes in? Let's face it, people they're not going to come in and say, hey, there's a whole ton of building code violations in here. And we have no way of knowing. The renters, what leverage do they have? They can't say anything. They're going to be in fear. So I just think that's something that we need to address. Otherwise, it's going to continue, and it's just going to continue, whether it's building or sanitary code violations. So I follow your point, Mr. Manager, but that was it.
All right, motion
Thank you,
to
Mr. Chair.
adjourn by Counselor Noon, second by Counselor Elliott. All those in favor say aye.
Aye.
Any opposed? The ayes have it. Stand adjourned.